have them look at our job postings.
I just didn't want you to go on.
Okay. Thank you. Let's begin our San Juan County Planning Commission meeting for April 10th, 2025. Commission in attendance. Oh, there's Ann. I didn't see you come in. Ann Austin, Shay Walker, Lloyd Wilson, Cody Nielsen, Melissa Rigg, and Thomas Garcia, Trent Schaefer. Commissioner Stubbs, Jens Nilsson, Kristen Bushnell. I don't know who else is Mac on.
And Max online.
Okay. Okay. Who would like to lead us in the Pledge of Allegiance?
I'll do it.
Good.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Does anyone have a conflict of interest on anything that's on the agenda tonight? Hearing none. Approval of minutes. I have two things. One, I did declare a conflict.
Okay.
And then the other one, Mark Wigand, is spelled Wigant, and he lives just north of Monticello.
Say that one more time.
What's that?
Wigant. And from Monticello. That's all I had.
Okay, I have one. So under administrative items, it says that I'd like to revisit the bylaw comments that were submitted last year. It was not just those portions, it was, I think we had multiple comments. So it wasn't just ethics and conflicts of interest. And it was Cody who brought up the issue of commissioners to be from unincorporated areas of the county.
How would you like me to put that? And other comments?
Yeah, and other comments, that'd be great.
And Commissioner Mon just came in. Add her to the list. Any other additions or corrections to the minutes? Hearing none, I'd entertain a motion.
I move that we approve the minutes as corrected.
Okay, got a motion
Seconded.
and a second. All those in favor of approving the minutes with the corrections, additions from March 13th, 2025. All those in favor say aye.
Aye.
Any opposed? Hearing none, motion carries. Okay, we'll need a motion to go into a public hearing for a rezone.
I'll make a motion to move to go into public hearing.
Okay.
Second.
Motion and a second to go into a public hearing to consider a rezone in Lisbon Valley Mine. All those in favor say aye.
Aye.
Aye. Any opposed? Motion carries. Okay.
Any comments for the public hearing? And I did not receive any comments.
Any online?
Any online comments for the Lisbon Valley Mine rezone?
Okay. Alrighty. I'll entertain a motion to close the public hearing.
Motion.
Okay.
Second.
And a second to go out of the public hearing. All those in favor say aye.
Aye.
Aye. Any opposed? Okay. Alrighty. Public comment. This is for anything that's on or not on the agenda. And
In-house first.
in-house first, 3 minutes. Any public comment?
Okay, we'll go online. Any public comments from online? Okay.
Moving right along. Administrative items. Bart. Good grief.
All right. My name is Bart Coons. I represent the county in litigation involving the Love's Travel Stop. I am here today based on the administrative law judge's ruling, and that's what I have here. I will distribute these to you. We didn't send these out as part of the packet because it's over 100 pages long and it is a very large file. I can get you a digital copy if you wish. Just let us know and I'll send you one, but I'm going to hand out these hard copies. I have included what I think is necessary pages from that in the packet that you were given. Oh, that'd be great. So if you'll recall, the Planning Commission considered the travel stop application and
See it, there we go.
Thank you.
made several decisions related to that, made findings that the travel stop was, I'm fine, thank you, was permitted. That was appealed by the Northern San Juan County Coalition to our ALJ, Judge Cresswell. Judge Cresswell rendered the ruling you have just been given. He affirmed several of the Planning Commission's decisions. For example, he affirmed that the Love's application was complete, that it was accompanied by the required fee. He agreed with that. He also agreed that it was controlled by the 2011 county ordinances, that it was not barred by the moratorium, and that it was also not barred or affected by the new Spanish Valley development ordinances. So those were his decisions. However, what he did instruct is that he wanted more findings related to whether this was a permitted use under the 2011 ordinances. And he also noted that Sitla is the owner of this property, and that there was no finding that, in fact, there can't be a finding that the county can regulate Sitla land, state land. And so he had an issue with that as well, that he wanted the Planning Commission to address. Insufficient findings of fact he held for the travel stop being similar in nature to a restaurant or drive-in, to a commercial parking lot, or to an automobile service station, and needed to either explain why this use falls within those permitted categories. So he wanted more on the why. And he also wanted to know if the Planning Commission was saying that it was an other use, then why was it in harmony with the intent of the neighborhood commercial zone, and why was it similar in nature to the other listed uses for that zone? So that's why we're back, where we will be coming back here now. What I'm here for is that he also gave us a list of instructions, and one of the instructions was that someone from the county attorney's office was to come to the Planning Commission and provide some information and details about the process for coming to these conclusions and what he's looking for. So basically, that's why I'm here today. We thought we'd split it up so you didn't have the decision one day and in my presentation the other day. I would do the presentation on the law and the legal aspects of it and how you go about the decision that Judge Cresswell's asking for. And then we would bring the next meeting, we would bring these remaining issues back up to you for decision. All right, with a staff report explaining everything and going through everything as well. So to go through that, if you could look in your packet on pages 10 through 12, this is where he is concerned about here the applicant. So, on page 10 there we have Utah Code 1727A304. Unless otherwise provided by law, nothing contained in this chapter, that's CLUDMA, may be construed as giving a county jurisdiction over property owned by the state or the United States. So that would pertain to the SITLA owning this piece of property. And so his question was really, if you look at the definitions, for example, a land use application under 103 sub 34 on the next page, it's an application required by a county and submitted by a land use applicant to obtain a land use decision. And it also defines a land use applicant in sub 33 as a property owner or the property owner's designee who submits a land use application regarding the property owner's land. So here the property owner is SITLA. SITLA is submitting the application. They have chosen as a representative Kim Van Dyke, who is a Love's employee, but they haven't described in any way or waived their right not to be governed by the laws of San Juan County because it's state-owned land. Therefore, what the Planning Commission will need is some sort of representation from SITLA or from Love's that SITLA is waiving any objection to the county's control and zoning and say over how they use their property that is at issue here. So that is one of the things that will be coming back to the Planning Commission when we bring this up again. The county is submitting to Love's and to SITLA requesting that they clarify their positions with regard to this property. And when we receive any response to that, we will bring it to you for your consideration when this comes before you next time. So is there any kind of question or clarification you want about that issue?
I don't understand. So if it's SITLA land and SITLA can do what it wants with its land, right?
Mm-hmm.
Why is it here before us at all?
And that's the question that the administrative law judge once answered as well. In my personal experience, having dealt with SITLA for years now, with regard to development and local governmental entities, sometimes they will, play nice with local governmental entities and, follow the zoning process for their properties. There have been periods of time when they have not done that. But this is one of those times it appears that they want to go through the county process and continue with that good relationship between SITLA and the county and not do anything to sort of disturb that. That's what I believe is happening. But again, we have nothing formal from SITLA stating that they're waiving any sort of objection to the zoning on their or applying the zoning ordinances to their property.
So we could turn this down, right? Just hypothetically. We could turn this down and then SITLA could say, you have no jurisdiction, we're going to do what we want.
They could do that, yes, under the statute. I mean, there have been challenges in the past to SITLA's authority to do that. There have been legal challenges. It's not fully resolved in Utah. But the argument from SITLA is that we're a state entity, and we're not only a state entity, but we're a trust entity, and we're required under our trust to do with the property what is in the best interest of, in this case, the schools for Utah. And if that means developing it in a way the county doesn't like, then we are enjoined to do that by law. And that's been their position for a while. Sometimes, though, like I say, they feel it's better to proceed under the ordinances of the local jurisdiction.
I guess I'm still confused. So who owns the property?
SITLA.
Okay, so Love's has not purchased the property from SITLA.
As I understand it, the relationship is that Love's has some sort of contractual right to develop that is pending approval, and at that point, then SITLA will transfer the property to Love's. But it hasn't actually been transferred yet because the development has not been approved.
Can SITLA pull out of the deal? Like, can they say, never mind, we don't want this?
I don't know what the terms of that agreement are. That's just what was presented at the hearing before the ALJ. They have an interest. So Loves has an interest in the property with Sitla. I believe it's contractual, but that's all I know about that relationship. But Sitla remains the owner, according to Loves. At the administrative hearing, that was the representation that was made.
Pretty clear.
So this came back to us
A
8
year
months
ago,
ago? A year ago?
February.
Was it February?
Mm-hmm.
For kind of the same thing at this point, right?
It's a little bit different. We have affirmation on the issue of what ordinances apply, whether the permit was complete, whether it was processed properly. All that's been decided. The ALJ agreed with Planning Commission on those conclusions. The coalition has petitioned for district court review of that, and that is now pending in district court. The county has agreed to stay that proceeding while we come back before you, get a decision on the remaining issues. That will probably also go through another hearing before the ALJ, and then it's likely that whichever way it goes, someone will probably petition for a review to district court on those issues. And then our plan is to consolidate it all into one court case that the court can then hear at the same time, just make it more efficient going forward.
Yes, my kind of question, since I made the motion in the finding that it was a permitted use, and I'm not you or gents, but I felt like, so you come back and like explain why. I don't know how to explain why any better unless somebody else writes. I mean, I've literally, like, it is this. It
Right.
It is a restaurant.
Right.
It is a gas station. It is a service station.
Well, and that's what the ALJ has asked me to do, is I can sort of explain what he means when he says I need more on why, and so that's what I'm going to try to do today, is explain what he's looking for, and then also in addition, we'll be working with the county planning staff to prepare an in-depth staff report for your review as well, that will hopefully provide a little more explanation on the why as well, that you can look to for assistance also. One of the things that was raised on the appeal was that one of the reasons for the permitted use was a commercial parking lot. And it was pointed out that that's actually a permitted use under the CD subzone, not the CDH subzone. So that was another sticking point up on appeal as well. So I'll talk a little bit about that as well. But before I do that, I just want to make sure that everyone is understanding where the ALJ is coming from on the ownership issue. Got that? Okay. So then moving on to the operation of Chapter 12, which is what we were just talking about. The listed uses, if you look at, I have Chapter 12 in your packet on page 14, starting there. The permitted uses, and the ALJ agreed that this is how you read it, that this list here are permitted uses. So we first have the community commercial, the CD, those are permitted uses, and then we have highway commercial on page 15, CDH. So those are the permitted uses under CDH, but those are the uses listed under CD are not the uses that are permitted under CDH. Only those uses listed under CDH are permitted in CDH. And so the ALJ, basically you have three choices. You can say, one, the use is contained within one or more of those listed permitted uses. Two, it falls under the paragraph after those permitted uses, which says other uses. Other uses approved by the Planning Commission as being, one, in harmony with the intent of the neighborhood commercial zone, and two, similar in nature to the above listed uses. So it's either or it's a combination, which could also be. It could be some of the permitted uses. It could also be another use that meets those two criteria, right? So those are your basically your three choices. And so the question is then, what do these listed terms mean? And if you look at your packet at page 19, that's where the ALJ in his decision starts going through what do these terms mean. So at first he talks about what is a restaurant or drive-in cafe. He notes there's no definition in San Juan Code about what this is. And so he starts looking at other law to try to decide what this is. And then same thing for automobile service station. What is that? And also finally ending up with what is an accessory building, what is an accessory use on page 23. So if you look at that, you'll see what he's driving, and he's basically saying a restaurant or a cafe. The ALJ provided these reasonable definitions, and so he basically said, this is what Utah Code says a restaurant is. This is what Ogden City, for example, says a restaurant is. This is what Webster defines a drive-in as. Those were all definitions that he finds reasonable. He looked at what an automobile service station is, and he concluded that basically it's a business that sells gasoline and other motor fuel, lubricating oil, greases, roadside electric car charging, and similar services for motor vehicles, including passenger cars, vans, motorcycles, trucks, buses, etc., including providing minor repairs, vehicle washing services, convenience store, mini market, and public parking. That's what he considered a reasonable definition of an automobile service station.
I agree.
An accessory building is a building not used for human occupancy, which is secondary to the main structure on the same piece of property, such as a shed or a garage. And an accessory use is land use that is subordinate and incidental to the main use on the lot or the parcel. So that's basically, he went through and he said, these are the listed permitted uses. This is what I think those words mean. And he said, I think that these are reasonable definitions of these words, which in my book means that the Planning Commission is free to adopt them or free not to adopt them at its will. But there needs to be some sort of, because he did it, there needs to be some sort of explanation on what the Planning Commission is interpreting those words to mean, because there's no definition in the code, right? And then he moved on and he started talking, starting at page 23, about what these other uses are. So these other uses are things that are not named in the list of permitted uses, explicitly not named in the list of permitted uses. And he said in other places, we have things like service stations, commercial parking lots, which is a permitted use under CD subzone, gasoline pumps, pump islands, parking spaces, convenience stores, travel centers. These are things that are also possible uses that are not contained in that permitted use. And so you need to go through a two-step process to decide whether that's an other use under CDH that is permitted. And this is the Planning Commission's determination. And the Planning Commission needs to determine if it's in harmony with the intent of the neighborhood commercial zone. And there has been fighting between the parties on what this phrase actually means. It's not exactly clear to the parties. The ALJ decided that.
Excuse me, real quick, neighborhood commercial zone.
Yes.
Where do we get that from?
Where
does that come from?
Yeah. So if you look at the chapter of the 2011 ordinances under, let's see, I'm going to find the page here for you. Page 15. So these are the permitted uses under the highway commercial zone, CDH, and it lists, restaurant or drive-in cafe, motels, and it provides that list. At the very bottom, it says, other uses approved by the Planning Commission as being in harmony with the intent of the neighborhood commercial zone. That's where that language comes from. And similar in nature to the above listed uses. So if the Planning Commission is going to approve another use that is not one of these listed permitted uses, then it needs to make two findings. One, that it's in harmony with the intent of the neighborhood commercial zone, whatever that means. And two, that it's similar in nature to the above listed uses. Okay? And so he provided some direction on what he thinks this means. He says, neighborhood commercial zone is undefined, but he's interpreting the commercial zone is the 1,000 feet from Highway 191. And the neighborhood means the surrounding area, situated near, proximate, adjoining. These are all words that mean neighborhood. And so he said here it could mean, and he said could. So, it's the Planning Commission's responsibility really to actually put some sort of definition to this phrase, whatever it means. That it could mean properties within 1,000 feet of Highway 191, both north from the property under consideration, the Love's property, to the county boundary, and then south the same amount of distance from the Love's property. So he views that as sort of the neighborhood commercial zone. So when you're looking at something that's in harmony with the intent of the commercial zone, that's how he is looking at what the commercial zone, the neighborhood commercial zone is. All right. And it has to be similar in nature to the listed uses. In other words, it has to resemble, it doesn't have to be identical, it just has to resemble and have common characteristics with those uses that are listed there. So now let's move on to talk about findings of fact and conclusions of law, because your decision is going to have both. You need to make conclusions of law, what the law is, what the law requires, and whether this satisfies the law. And then if you determine it does or does not satisfy the law, you need to make findings of fact that support that decision. And that's where Judge Cresswell got hung up on the last decision. So the legal conclusion is whatever's based on laws. What are the federal, state constitutions, state and federal law, your local ordinances? This is all the law, right? And so the Planning Commission needs to conclude that this application meets or does not meet whatever the legal requirement is. It's spelled out in the ordinances. So, for example, Love's Travel Stop either is or it isn't a use listed as permitted in the highway commercial zone. That's a legal conclusion, right? And then that decision, when it gets challenged, is reviewed for correctness. So a judge or the ALJ is going to look at it and say, did the Planning Commission get this right? Was this legal conclusion that they made right? It's a different story when you talk about facts. And the facts are why you came to that legal conclusion, right? Let's say it is a permitted use. Well, why is it a permitted use? And these facts must be specific. And when they're reviewed under what's called the substantial evidence standard. In other words, the judge isn't just going to look and see whether it was right, but he's going to look and see whether there was any evidence in support of the decision. And it has to be something beyond a scintilla of evidence, but it's something a reasonable mind would accept, right? So if this looks reasonable, I'm going to accept it, okay? So, for example, we can say Love's Travel Stop is or isn't a use listed as permitted in the highway commercial zone. If it's not, you just say a travel stop is not listed as a permitted use. That would be one of the findings that you make. Or you could say if the use can be permitted if it's contained within several different uses, but it still doesn't qualify as, for example, an automobile service station because, it's got bays for trucks fueling and it has truck parking. Therefore, I don't think it's an automobile service station. So that would be facts to support your conclusion that it's not an automobile service station and it doesn't fit within that definition. Or you could make a conclusion and say, let's conclude that the use is contained within several different of these listed permitted uses, and then you would have to make findings to support that. And some findings might be, if you conclude that it is contained within several different listed uses, you might conclude, oh, it's an automobile service station. Well, why is it an automobile service station? Well, because the plan is calling for 16 fueling stations for automobiles, 90 parking spaces for automobiles. And it seems to have more of an auto focus than a truck focus. So I think, the commission could say, we think that therefore it is more like an automobile service station and fits within that permitted use. And it's also a restaurant or drive-in because it's going to have a fast food restaurant and a drive-through for that. So, et cetera, et cetera, et cetera. You say, conclusion, it is contained within automobile service station. Why? Because this is what the plan says, and that fits within the definition
of automobile.
Right.
I mean, just like I agree with his definitions of a service station, like I would use his, fine, he researched it.
Right.
I would also say, we could get so nitpicky as an automobile. You say, well, an automobile, it services this many. Is a truck not an automobile?
Right.
Do we need to look that up gents at Webster and say, hey, you know what I mean? Like literally, that's
Yes.
what we're down to.
And in fact, we did argue about that at the hearing. What is an automobile? From Love's perspective, automobile includes trucks. From the coalition's perspective, automobile does not include trucks. And so that would be an example of a conclusion of law that the commission would need to make. We're concluding that automobile includes trucks, and therefore an automobile service station, this fits within that
Is it
that
light
definition.
truck or heavy truck?
Yeah.
Semi-truck.
Yeah, a semi truck, a tractor
Anything that's
trailer.
not
Yeah,
horse-drawn is an automobile.
right.
I mean,
Yeah, the arguments go on and on and on. You can continue getting more and more specific, which is what lawyers are famous for. But you're in a position where you've got to make conclusions of
that's
law.
what they want, and they want to basically see that that's what we've done.
Yes,
I mean,
they want to see that you've made the conclusion
I can't
and then
just
explain
think. I've
why.
got to actually,
back up your thought
okay,
process.
like I
Right.
am supposed to define automobile, what we as a commission think an automobile is.
Or an automobile service station. I mean, you don't have to go that deep if you agree what an automobile service station is. But you're right. If you have an argument about what an automobile is, and that affects what an automobile service station is, then that's going to play a role into what your conclusion is going to be. Right?
It's gonna be a long meeting next month.
I have a question about the neighborhood commercial zone.
Mm-hmm.
So,
It's not a zone. It
Well,
just
that's-
literally, it's just an area. Wherever
Each
it
zone has
is.
the same language in it.
I mean, it's
Well, no, it
just
doesn't.
that
it
phrase.
doesn't. Each
Yeah,
zone
the
doesn't
phrase is
have the
the
same
neighborhood
language.
commercial zone.
I
Yeah.
looked.
Are you sure?
Yeah, I
I
looked
read
at
through it and I
commercial.
saw it.
But there's
But
like
this
a
is
definition
not
of zone. A zone as in a defined category in the
'Cause like it'll
ordinance,
say-
or a zone as
Yeah, but
in
it doesn't say.
a neighborhood.
Doesn't say
That's
Right.
just an- oh, yeah,
Right,
it
and,
says
and so that's why I explained to you the way he is interpreting that, because
it's
it,
bad.
right, because it's not an actual, it's not an official zone. The language seems to be more generic than that, and that is the way Judge Cresswell interpreted it. He said basically it means the commercial zone that it's sitting in, which is highway commercial,
Okay.
and then it's within the neighborhood within that zone.
I mean, if I
And so that's how he interpreted it,
Yeah, so
as
I
being
defined
1,000
it would
feet
be
because that's the commercial zone, and then
neighborhood
north and
commercial
south of
zone
that
would be
as the neighborhood.
neighborhood
So,
area zone.
so my question has to do with when he's talking about the 1,000 feet.
Yeah.
Does he go outside of highway commercial when he says that?
No, because he's using that because that is the commercial zone. The commercial zone is 1,000 feet from the,
1,000
yeah.
So it's just that, regardless of where the point is.
Yeah. What do you mean by point?
Well,
The property?
Yeah.
Yeah. Well, the property is within the commercial zone, so it is within that 1,000 feet.
Okay.
Yeah.
That's the 2013 map just has that snake of highway commercial throughout the entire county. It's 1,000 feet from center of highway. And when we've pulled it up and measured it on like Google Earth, it basically goes to the ditch behind. It goes all the way to that ditch. So it's not just this property. It's also including the property behind it was within that 1,000 feet.
Okay.
Right.
What is in that property behind it?
That's where you have the big warehouses. That's Moab Business Park.
Business park, yeah.
So the legal conclusions that Judge Cresswell has specifically asked for are: one, does Loves have a property interest in the property, or has Sitla voluntarily waived its ability not to be bound by county ordinances? Two, can the use be permitted if it falls within multiple listed permitted uses in the CDH zone, not just one? Three, if so, does Loves fall within the listed permitted uses? And if not, or if Loves doesn't fall within the listed permitted uses, is it one, in harmony with the intent of the neighborhood commercial zone, and two, similar in nature to the listed uses? So those are the conclusions he's asking for, and then he wants specific facts explaining why the Planning Commission concluded the way it did.
So can you say the first one again, because that has to do with Sitla waivers,
Yes.
right? So
Does-
we have no power over that.
You have no power over that, but you can't. What he wants to know is, does Loves have a property interest that makes them the property owner, or if not, has Sitla voluntarily waived its ability not to be bound by county ordinances?
So how can we vote?
The county is requesting some sort of representation from Loves and Sitla on this issue, and we'll report that to you when we bring it before you at the next meeting. Okay.
And we'll kick out this portion of information sooner than the packet because it's going to be substantial.
Yeah. There'll be a detailed planning staff report on this. So
So I have one other question. So are we going back to granting a conditional use permit for this property?
that question, that is not one of his questions that he's kicked back.
Okay.
Yeah.
Do we need a public hearing on this?
Yeah. No, this is just a question of the decision that the Planning Commission made last time. There are parts of it that he didn't feel were adequately supported by facts, and so that's why he's sending it back. He's saying, I need you to make these legal conclusions, and then I need you to give me facts that support those legal conclusions. So it's just basically sort of a redo of part of what the Planning Commission did last time.
So yeah, we're not basically changing at all what we said
just
last
backing.
time. We're just basically saying,
You're supporting it with
I would
evidence,
say
more
that,
evidence.
like, it's both 1 and 2. I mean, it's permitted, and it's also in harmony, I guess, was the harmony with the intended neighborhood commercial zone.
Mm-hmm.
And then Jens or somebody's gonna define his definitions and other definitions. Why? I mean,
Well,
basically.
so let's take that as an example.
Well, but I'm just saying,
Right.
obviously.
If you were to say that it was a, I'm sorry, what did you say again? It was a permitted.
It was permitted
And
for
in
the two,
harmony.
But you
As
don't have
as
to
what?
vote.
What permitted use?
as the restaurant, the service station. What did I say last time too? I mean, we'd have to go back.
But if you said, so for example, if you said, I think it can be permitted if it falls within 2 of the permitted uses here. One of those is a restaurant, and one of those is an automobile service station. If you were to say that, then you would need to also say, these are the reasons why I think it's a restaurant, because it's going to have a fast food restaurant with drive-through service. I think that falls within the definition. And then you say, I think it's going to be an automobile service station because either 1, I think automobile includes, tractor trailers, or B, I think an automobile service station, that this falls within the definition because, and then explain what from the application makes you think it's an automobile service station. It's got gas pumps for cars. It's got,
because
yeah,
last time I remember saying, because it'll have an Arby's. And what is an Arby's?
Right.
Arby's can be a drive-up. You can also go and sit down.
right.
It's not a Cracker Barrel, but it is a
Restaurant or drive-in.
Right, right.
And this one actually has 3.
And so
So you need what Judge Cresswell is asking for is very specific. So, for example, you would say, these are the permitted uses that are listed here that I think it falls under. This is why. If you're going to also go to the other uses provision, then you need to say, I think it's in harmony with the intent of the neighborhood commercial zone. Why? And I think it's similar in nature to these listed uses. Why? So you need to have the why on every single decision, sub conclusion that you're making. I think that's what he's looking for.
Gotta think like an attorney.
that's the last thing I want to do.
And we hope to have in the staff report some guidance of possible conclusions you could make and accept if you were inclined to.
I understand.
Bart, hypothetical, if we could get the new ordinance 2025 land use passed, in it, a definition of a permitted use is a travel center,
Mhm.
truck stop. What would happen if we passed that and they reapplied under the 2025?
Then if they reapplied, after the 2025 was adopted, then they would be bound by the 2025. So whatever the 2025 provided, that's what they would be considered under. Their application would be considered under.
Would it allow the lawsuit to go away?
I feel like, based on the litigation that we've had, this litigation has been going on for several years, that I don't think litigation will disappear, because I think that whoever ends up on the losing end of the vote is probably going to pursue litigation.
Well, we've talked previously about if they were to reapply, they start the appeal process over, versus at this point in time they're so far down the line that they would probably try to see this.
No, what Trent's saying is if it's a permissible use in the new ordinance of 25, there wouldn't be any.
But they could still
They
appeal our
could still come and say,
decision,
well, our definition wasn't.
or appeal
you
the
know, like-
administrator saying it was okay, and so then they start over.
Gotcha.
I mean,
Yeah, if they submitted a new application, it would be a start over.
I guess I just am a little bit. I don't think anybody really. Back to the other one that will come later, is the ownership clarity. That scenario there, how that plays out. I don't think. This is just my opinion. Nobody cares about my opinion, especially this judge didn't. So, but I mean, I don't think Sitla has waived their right. Like a lot of applicants, they will come in and they will have a contract with a regular landowner and say, well, they want to get the conditional use or whatever the use is first in order for their, to be contractually obligated to go forward and own the property. But I don't think any of us can answer that question that, Sitla, in no way have they waived that.
Right. I think what the judge is looking for is that under state law, the land use applicant is the owner of the property. So Sitla is the owner of the property. Also under state law, Sitla is not bound by the county's ordinances. So the judge just wants clarification on Sitla is voluntarily going through this process and is going to abide whatever the ordinances are. That's basically what I think Judge Cresswell is looking for.
For Sitla and Loves, if Sitla just says, well, we're going to allow it to be a permitted use under, they just.
Well, I think can they
they
leave
just-
that
can they
vestiture
just-
at any time? Like, we're gonna play nice, but since it's not going well, now we've decided we're just gonna do what we want. Or once they start the process, do they have to see it through with the county?
All I can tell you is what there's no reported case law on that statute, so I can't tell you what the appellate courts have said. But the statute says that they aren't bound by it, which would mean to me that that even going through the process, I don't know that they would have to conform.
I would just like to see Loves just personally and Sitla just say, okay, we'll allow it. You go ahead and build it, and we will do a 50-year lease or a 100-year lease, and so they maintain ownership. They maintain their authority. How does that work as far as if they did that? How does that work as far as permits and do they not?
Well, the way I understand the agreement is that once the project is approved, my understanding is that at that point Loves would take an ownership interest. So at that point, it's no longer Sitla land. So they would be bound by all of the county's ordinances and building inspections, et cetera. So
I'm just saying,
So
hypothetically,
lease versus owning.
what if they just lease it and they build it?
I think that at that, we would have to look at what the interest was that Loves had in it and whether it's a property interest or not, whether they could be classified within the category of a property owner, because that's what the statute says. It's a property owner. So that is what we would be looking at.
So more or less, the judge's question to Sitla is, how is this going to end up? Are we going through all this litigation, and in the end, you're just going to flop on us and say we're doing what we want anyway? That's why the judge is wanting an answer from them or Loves at this point.
Say that again. Sorry.
The judge is wondering at what point does Sitla just flip and say, never mind, we'll just do whatever we want? Is that kind of why he's wanting to know what their mindset is at this point?
I think his concern is, look, if Sitla does not have to go through this process, why are we going through this process? Yeah. And I believe we're going through this process because Sitla wants to maintain a good relationship with the county and wants to conform to its ordinances. That's my belief. I don't have anything in writing that says that, but that's what we're going to try to get from Sitla. So.
But you just described a scenario where Sitla can do whatever they want, but yet it turns over to the county if they sell it to Love's.
Right, and so
it's a moot point, right? So they can't really do anything without outside of the county's jurisdiction.
Well, there have been cases I've been involved with in the past where Sitla will actually grant development rights before it sells the property.
Okay, so then they grant the development rights. Love's develops it, but they may not want it because they don't get to own it.
Yeah, that might be an issue as well, because whatever works best for the Sitla's view is whatever earns us the most money for the trust is what we will do. Because that's their injunction under the law. That's what they're supposed to do. They're supposed to manage that land to get the most money out of it they possibly can.
Instead, it costs the county thousands and thousands of dollars, where Sitla could take care of this in a heartbeat.
They could, but the county might not be very happy if they did that. I have been, in the past, Sitla has made decisions that local entities have really been opposed to, and it has caused very rough relationships between the local governments and Sitla. And this may be a new way to, work with a governmental entity.
This is the other way. Like, Sitla has literally tried to sell this and has put the county in at this point, endless legislation. Litigation. And so I'm kind of the other, like, well,
right.
Help us out, Sitla.
Yeah.
Does that make sense?
Well, that's one way to look at it. I think Love's looks at it as Love's has been trying to develop this property, and it's been challenged through many processes as well. I'm sure the coalition looks at it and says, Love's has been fighting us every step of the way on this. Everybody's looking at it from the perspective of the other party is the one that's been causing problems and making it more expensive. It's not just Sitla, and it's not just the Love's, and it's not just the coalition. Everybody is pointing the finger at everyone else.
So what happens if this planning commission cannot adequately defend its decision and satisfy Cresswell?
If they don't satisfy, if we go back before Cresswell and Judge Cresswell decides against the planning commission, then the county is going to need to decide what it wants to do at that point. That's going to be a decision made from the county attorney's office and county commission's level on how they want to approach it, whether they want to, fight that, or whether they want to, their options at that point would have to be something they would consider, and then I take direction from them. So, I have no say in what happens after that.
But that is a possible outcome.
It is a possible outcome, yes.
Are there any other possible outcomes?
I am too.
I'm confident we can describe the why of what we decided.
Well, just to plant a little seed in your minds between now and the next meeting, for a minute, go Google image what an automobile service station is, and go Google image what a truck stop is, or a travel center.
By Google's definition.
It's a reasonable thing to do. I'm just saying, you will see cars on lifts in an automobile service station. So there's some just really logical, obvious things, but we can grasp for straws and try to redefine the term of automobile service.
Right, and I just want to reiterate, whatever the decision is, the factual part of that decision will have some deference, because it all it has to do is be enough to convince a reasonable mind. So that's what you're looking at with your facts, laws, legal conclusions. That's whether you're correct or not. They're just going to look and say, I don't think that's right. I don't think that's a correct reading of the ordinance, and reverse on that ground. But for facts, it's deferential to what your findings of fact are, whatever they may be.
And we could say that a truck stop is not a permitted use, but we think it's in harmony with the intent of the neighborhood commercial zone for XYZ reasons and similar in nature.
Yes.
We have that option.
Yeah, that's an option as
And
well.
we have
Kinda
one more
difficult,
option. I think we have one more option too, which is that we say it is not an other use approved in harmony with the neighborhood commercial. So then that would kick it into conditional uses, all other uses.
I don't know about that because I don't know what the conditional use options are for CDH, but possibly. I don't know if it's a conditional use. All other uses are conditional in CDH. Yeah, so it could be
just
considered
all
as a
other
conditional
uses.
use, probably. Yeah, because it's all other
I'm
uses,
just-
right? Yeah.
But for
Thinking
that,
through
you have
all
to have
of
the
the
same
all
findings
the-
of fact. Why
Yeah.
that is your.
Yeah, you could come to that conclusion of law. You would need to support it by findings of fact. Yeah.
But I guess my little thought on it is nothing has really. What we said last time is still what we're still saying. We're just going to go through the process.
It's still
to
what
find-
you're saying.
Well, it's what the commission voted on. I will say that. What we all approved.
No, we didn't. It was not a.
It was not unanimous. Yeah.
I'm honest
Yeah.
with you.
Yeah.
But we just need a better, a more defined finding of facts to support those.
Conclusions of law. And like I say,
Just saying, I don't want
Change your
to.
decision.
We're not going to go back 6 months and redo everything we did 6 months ago. We just need to
Define what we
define
did.
the finding of facts of why we found the way we did.
well, I mean, he wants to know if you're finding it a permitted use.
Which we said that.
Right. So if you are, then explain like which permitted uses, why.
I thought
Right.
we had.
One of the questions is, can you have it in more than? Does it fall within more than one permitted use? And if so, why are you deciding that it can? And if it can, then why are you deciding it's under each one of those? So he wants that. Or if you're going to go with other uses, or if you're going to go with permitted uses and a combination with other uses, then he needs those findings on the harmony and the similar in nature. Okay.
Okay.
Yep.
All right.
We can do it.
All right. Anything else?
Cody can do it.
All right. We'll plan to have a staff report to you in your packet for the next meeting. So, all right. Thank you. Yeah,
Are you allowed
Jens.
to give a model answer to the commission?
Well, I think that the way that the staff report typically does is staff makes a recommendation, and then the staff proposed findings that can be made. And so I assume that's what the staff report will do here.
Include some like the language cues, and then you guys can fill in the blanks. You can take option A, B, C, or D. You know.
Would you agree that the last answer given would have satisfied a lot of ALJs around, but not Lynn Crystal?
I'll let you say that.
It's not a
Yeah.
negative on him. I'm just saying he's very particular.
Yeah, I mean, Judge Cresswell's extraordinarily thorough, and he's going to provide a decision that's going to have all of the facts in it that are necessary for an affirmation. And so that's what he wants, is he wants to be able, if he's going to affirm the Planning Commission, he wants to have the facts that will allow him to affirm the Planning Commission. That's what he's asking for.
Jones, what did you mean by the last answer given?
So I was here at the meeting when all this was discussed, and I remember feeling like the stated reasons, were quite specific and supported, and that they were clear enough, in my opinion, to not require a new, more specific answer,
Definition.
findings and so forth. And so Judge Cresswell is, as Bart said, his manner is to be very detailed and very thorough. An A answer for him is going to be a lot more work than a B answer. And so I was just trying to point out, I think that
I thought I got a solid
yeah,
B
I
instead.
just
We
feel
got
like,
a
I just feel like, I don't,
But you need an
I
A.
don't feel like you,
Huh?
You need an A.
Well, I'm a B student, I guess.
I think this is more doable maybe than you. As I'm looking in your eyes, I'm seeing how are we supposed to do this, and I'm thinking, no, I think it's more doable than you.
It's
think it's
it's
easy.
doable.
I
Yeah.
think it's easy.
So who was the administrative law judge back in 2019 when it was first appealed?
It was the wait, I'm going to say this wrong. When it was first appealed, was it?
The county commission.
It might have been the
was
county
land
commission
use
because
authority.
it went. I believe there wasn't an intermission between county commission being the appeal authority and Judge Cresswell being the appeal authority. So I can't remember if this was before or after that transition.
So he could have heard this back in 2019.
It could have, but I don't think it was him, but I don't remember, to tell you the truth. Okay.
Thanks.
All right. Thank you.
Thank you, Mark.
Hey, Kristen, would it be possible to get like the original application for permit?
Yeah, we remember that like 700-page packet. That was the February packet.
759 pages. You don't remember that one?
So I
Like 2
will.
months ago, February?
No,
February,
a year ago.
I wasn't
He wasn't here.
Oh, my God.
So I will get
You
you.
missed it.
700? Never mind.
And then I'll.
Too many
What we'll
pages.
do is we'll put together a packet with Bart here and get it to you ahead of time, which will also be included in your planning packet, because you know that Monday before isn't going to cut it on that many pages, and we'll just get you everything. You don't have to read it page by page, but just in summary, so you have everything.
Okay.
But I think again, like Cody said, we can't go backwards on our decisions. We just have to affirm what we did decide. And so it'll be a long meeting even at that.
Well, I'd kind of like, and maybe it's in here. I don't know if it's in here. The minutes and the motion that we made,
Sure.
and the explanation we had, so we can try to go.
I'll put together
More
everything
detail.
I got
Yeah.
for you.
Okay, legislative items. Consider a recommendation to the county commission for a zone change at the Lisbon Valley Mine for on-site employee housing.
Motion.
Okay,
Second.
I feel like this is deja vu.
got a motion and a second to make a recommendation to the county commissioners for a zone change at Lisbon Valley Mine for on-site employee housing. All those in,
I was just going to say, with all of the conditions we put the last time around.
Now this is not a conditional use.
No.
No,
This is
this is
a
a
rezone
zone
change.
change.
Zone.
You,
Yeah.
Okay.
this is just a rezone. They're going to multi-use.
Okay.
okay? Any further discussion? All those in favor say aye.
Aye.
Any opposed?
Opposed.
One opposed. Motion carries. Okay. Number 4, consideration and approval of project plan and development agreement for Valley Estates subdivision.
There's one correction for this that came out of a legal discussion on Tuesday, and that is that this board is not deciding on the development agreement, that is an administrative piece. So you are deciding tonight on the project plan only. The development agreement will run through our chief administrator and county commission.
Okay.
Why is that?
Because that's how it's written in chapter 10.
It says planning commission or
And or
staff.
On the
it's just
development
that
agreement.
because the development agreement is a contract,
That one
Um,
goes.
it will
just
go through
administrative.
legal and chief administrator.
I just want to double check that since we.
Okay.
And we have,
You guys
they're
did
back
your will
for
serve.
more. So if you have any
I
questions,
haven't heard from Dawn. I asked her about it.
So there's not a will serve in here.
there is a will serve. It's in here somewhere. And the will serve was actually for less units, correct, than originally more.
The original will serve was for 180, now it's for 190.
Oh, I did get a new one.
So there's the will serve dated just a few weeks ago.
So is that in our packet?
Yeah,
Yeah.
I saw it.
It's on page 47 in your packet.
Okay, and then you just passed by some.
So this was the original plat.
Oh, that's the original one, but not the plan.
Right. So
That we're
this was
looking
the
at tonight.
original submission. And we agreed that all of it had the overnight accommodations overlay. And that was in December of 23. And here is, we're getting there. And here are, wait, that's not yours. Wait, that is yours. Where's your map? I don't see your map. Like it's in there somewhere. There it is. Okay, so there's the engineering, there's the concept plan. So you are essentially this concept plan, this project plan is what you are approving tonight.
But there is language in this development agreement that refers to plats.
Yep, and they're not to the point of platting it yet. So when they get there, they'll be going through the subdivision process, but we're not there yet until we approve the project plan.
So in the project plan, we are looking at density basically. I mean,
Yeah, density is a big part of it. This is, we discussed it, this is kind of your maximum density. So they could go less depending on the market. They might do more single family homes, but we're kind of approving this as the densest that it can be.
and so we're looking at this in relation to what ordinances or
There's nothing in chapter 10 that talks about a chapter project plan. It just says project plan, development agreement, and plats. That's the last part of what's in there. Beyond that, there's no discussion of project plan, what the standard is for a project plan, what the requirements are for a project plan. It just says project plan.
yeah, because I think
Now,
this is
go
ahead.
if you go to chapter 2,
Mm-hmm.
then chapter 2 builds it back into the community structure plan. Chapter 2 covers all that Sitla land up there, and so there's a lot
Plan
more
development.
detail with that. But when you come down to chapter 10 with the project plan, it's the only place it appears is in the table.
Okay.
So there could be minor changes to this. For instance, maybe they bump a road over a lot or two. You know what I mean? So that to meet up with that community structure plan. But we are approving the idea for them to move forward so that they can start platting it for lots and they can start finding contractors for the infrastructure and all that. But they're not, until we approve this, they are not at that step yet.
So we don't know anything about utilities.
They're not there yet. So all
So
those
what are
types
we really
of things,
looking at? Just
those types of
pretty
things are going to be
pictures?
covered
I
when they
mean-
pull a building permit, right? When after we approve this, if we approve this, then they'll plat it. They'll get that done with the county recorder's office. Then they'll start to put in their utilities and pull building permits and work with the roads department and all of that.
This is just really important because it's the kind of the first one. Like, what did we do? Did we have one of these that we have gone through a project that's gone through this whole Spanish Valley overnight accommodations process?
Hassan Estates, which that was before my time, but I saw the plat for it that was left over in my office. That was a condominium community of 96 units.
And did that move forward?
It wasn't supposed to.
They have it platted
And
with
we
the
were presented
recorder's
with a
office. But I don't know where that one's at with like a development agreement or that. But they did get to the point of going through the subdivision process and recording those lots.
I just want to make sure we're consistent with this property, with this applicant, the previous applicant, the future applicant, that we're following our ordinance and that we're actually treating everybody the same in this approval process.
Just to comment on the agreement, section 4 talks about as you go forward with the development, you're gonna have to get all these approvals, you know, for all your infrastructure and so forth. So what I'm hearing is some of the questions that it seems like you might have, the development agreement addresses those and requires compliance when that all happens. I don't know if that's helpful or not.
Well, before we're a deciding body on approving Hassan Estates, were we not? Did we not vote on that? But now in this case, we lost. That authority has been taken from us, and now we're just approving a concept plan, basically. Along what lines are we supposed to scrutinize it?
I'm not really sure I understand your question. I wasn't around with the Hassan. I don't believe in. I don't recall that development. So maybe the applicant, if they speak further, will answer the question. I don't know.
Well, I can tell you this. If I don't know the one that you're talking about now. I know with Balanced Rock, if you go to, so there's the 3 pictures that you have. 2 of them are engineering, then the third one sort of is more of the trees and the stuff like that.
Pretty picture.
But if you take those first 2 and you hold those up against what Balanced Rock had when they came in on their application, they were showing things like duplexes, single family. They had roads in. They were showing some connections and things like that. It looked very similar to what you see here, with lot layouts, and then we've taken the additional step here of just trying to add some more structure to it, to be able to show not just lot lines and sewer, storm drain, things like that, but also how units would fit. So the idea of what we were trying to do was to come down and say, look, here's the property, and here is, and in the development agreement, then that's when we're going to establish density and side yard setbacks, those types of things. So what we've tried to do is to give you as a planning commission an ability to look at this and see how we're coming up with the things that we're asking for, and we're not just coming down and picking out a number and saying we want this density or we want that density, but if we have a density of this, here's how that can look, and here's how we've got single family, here's how we've got multifamily, here's how we're trying to address affordable housing and those types of things like that. So we're trying to give you a fairly comprehensive look from like a completed structure picture, which is the one with the trees and stuff like that, and then also with the engineering on here of how we conceive the project coming together at this point. So, and that's without the benefit of anything here in chapter 10 that says, here's what a project plan is, here's what you need to include, here's what, needs to be addressed, and those types of things. We're just trying to give you literally a picture of what we see the capacity of the property to do in order to be able to help you understand what it is that we want to do with the property.
So it's kind of like a preliminary plat that we used to get, and then what about?
Well, so we at our legal meeting on Tuesday to discuss this. The development agreement is going to be handled by Macon County Commission. The subdivision plat is going to be handled by myself and the plat review team. And so this and/or only leaves the project plan. I mean, it is not clear, as we discussed.
Why are you removing the planning commission? Because these folks have.
Because the new subdivision ordinance has it run through the plat review team.
Not when it gets this big.
Right. This is now a planned unit development, which requires a development agreement handled by MAC.
But it also should kick it to the planning commission. If it's under a certain number,
But they're not
But
there
this is
yet. I
over.
mean, they're not.
But so we're gonna get to see it again? Is that what you're saying? Because it is a planned unit development?
No, we're on step 2, right?
You're on.
No.
This is the third and final step for them for the overnight accommodation. So after this, they will plat it with a surveyor, and you will actually see the lots
We won't.
It's
flagged out there.
It's not coming back to us, and it's what you're trying to tell us. Whereas I'm arguing, I think it should come back to us, just like a planned unit development would.
Hence the problem with Spanish Valley ordinance.
Well, but it's also the practice that has been done in the planning commission for years. You guys were always the ones to look at the final plats and sign off on them, and especially with this size.
So, I don't usually agree with Ann, but
God forbid.
no, go back up there where we were just at.
Right here.
Step 2.
So they're done with step 2
what
because
is-
she got through that.
When?
January.
But this is a different plan. Because if you
It
look at
is
the
not-
proposed primary uses,
It's not a different plan.
Okay,
It's a
go
plan
back up there real quick,
extension.
please. Kristen, read that second one. Number of rooms and units. This has changed, has it not?
No, the approval was to apply the ordinance to the property. If you go back, the legislative body for the county is the county commission, and if you go and you look at what was presented to the county commission in January of last year, it was to apply the ordinance to the entirety of the property. So the legislative process of applying the ordinance to the property is not to a specific number of units or a specific combination of units or
But
a
that's
specific
not what
portion.
that just said.
No, if you go back and if you look at what the county commission voted on in January of last year, the commission voted to apply the ordinance, chapter 10, to the entirety of the property, not to a portion of the property.
Including those
So if
future
there's
phases.
some confusion within one of the particular documents, the legislative item that was voted on by the county commission was not specific to a particular plat or to a particular plan. It was specific to both parcels of property in their entirety. And so the
Without
legislation.
those details of rooms.
So that makes no sense as I read that in chapter 10.
So she got through steps 1 and 2.
Okay.
And he did them at the same time. So we approved 1 and 2 at the same time, and that applied to those future phases which weren't defined yet because he was phasing it out, but he wanted the overnight accommodations for the whole chunk.
Can I go back to, because I voted against the overnight accommodations overlay. It was not allowed in residential flex, right?
So that's where Sheik did the 2 and 1. So he rezoned to residential flex and applied the overnight accommodations.
But chapter 10 says you can only have overnight accommodations in highway commercial.
And then we had
But if-
all of our attorneys decide that it's only not allowed in SVR.
The
The last decision by our county attorneys was all zones. It was a permissible for an overlay other than SVR.
So yeah, if you go back and if you listen to the discussion before the county commission in January of last year, Mac brought up the fact of what you just brought up, Ms. Rigg. Did I get it right? And apparently what had been decided is that Balanced Rock, which is to the north and to the east of this property, had come in and they were presenting like a lodge and sort of a recreational club kind of a concept. And so because that had some similarities to the highway commercial, is that what you just read that it says?
Yeah, it's highway commercial.
Then the decision was made that Balanced Rock and that this property would be able to fall within that and that the overnight rental could be applied to it. I wasn't around at that point, but that's the only explanation I've heard is those discussions from the county commission meeting.
Well, I like the density. I like the idea of more housing in the area. I just don't like the overlay.
I understand that.
It's funny as I'm the one that made the motion to approve it and Ann seconded it last time.
What one to prove?
To the overlay.
Well, only because you guys had already established that with doing that for Balanced Rock. If that hadn't, because I was opposed to Balanced Rock getting rezoned, So anyway, it's just now it was unfair to these guys because they're right next to him. So that was my logic there. But so why are we even seeing the development
That's what I was going to
agreement?
say. Why is it here then? We're past step 2.
The development agreement, you're just approving the project plan. That's it.
But then why?
Because they are providing these 3 things. They are going to be providing a development agreement, which you have a draft, but you're not touching that. A project plan, which is what is in front of you, and a subdivision plat, which is their next step. So development agreement and subdivision plat will be handled administratively as we continue through the process. You are just approving that project plan.
That is outside of
Density.
what has.
You're
practice
approving the
has been
pretty
in the
picture
past.
tonight.
I
But
appreciate.
based on what though? What are we scrutinizing this concept plan against? Like, do we have an ordinance? We don't have anything to approve or not approve. It's just
Yep.
nice work.
I
Formality.
can tell you the
So that
question.
makes it more
The
of a
question you're
preliminary.
asking is the exact same thing that we've been doing and putting it together, which is if we're going to come to the commission and say, please approve this, then what is
So
it
this is the
we're saying
highest
we've complied
density, so they could do more single family homes.
The real question is what
But they
does
have the
ordinance
will
say
serve.
require, and that's
I don't know. That's why we're going back on you right now.
I think what we're establishing is that this was all approved in full.
I'm like, and
This is
just
like loves.
this is just a
Oh, don't let it be like Love's.
So now that the development agreement
and
is
or other
stripped
reason
away,
that we just did
and the
this.
final plat issue is kind of stripped away, it's supposed to make it easier for you to say, okay.
Yeah,
You
but
just
we don't
want-
have
no,
anything to
it-
base it on.
It is literally, we're just trying to get planning commission's good graces to move forward in the process before
But
they.
there's nothing set in stone here for us to agree or disagree on. You know what I mean? There's nothing to say, oh, I don't like.
See, and I don't-
What?
I don't see any requirement for us to make a recommendation on this one. I think it more or less at this point it goes.
And if you
we-
want, you
we
can leave
went
it
through the first 2
to.
steps. If you go back to that ordinance, chapter 10.
You would be fine if you do not want to give your good graces to just say this is an administrative decision.
I really think it is at this point because we've already went through step 1 and 2. That was the stuff that was required of this board. Step 3, it's the commissioners and administration.
It's not commissioners. It's me.
So I have a question.
Staff and or yeah.
If I buy a piece of property zoned what we've already approved this to be zoned at, and I want to put a duplex or a triplex on there, is there anything telling me I can't do that?
Like not in this development. You're just like
Yeah,
out there in the wide
by
world. You want to do a
myself.
duplex.
But same zone though we've already approved for it. Is there any would I have
If
to come before
if
this board?
multifamily is allowed in
Apply
that
for a
zone.
building permit.
So
Yeah,
the
if I'm in
way,
the same zone.
can I answer your question?
Yeah, please.
So the way that we're approaching this is that the building code applies up to a 4-plex. So there's nothing on here that we would do over a 4-plex. So for us to be, so right now, if you look at chapter 1 of the San Juan, of the Spanish Valley zoning ordinance, you can do single family dwelling and on 1/4 acre lots, and then you can have duplexes. And so in order for us to be able to get to the types, some of the types of units we want on there, the smaller units, then within the development agreement essentially becomes our zone. So that's where, so to the extent the county has oversight over the things that you're talking about here, that oversight is exercised within the development agreement. So for example, to have a provision that says that there can be single family and multifamily up to a 4-plex that's, under the terms of the International Building Code, which is Utah's state code,
Right.
something like that. So that's where it would have to be taken care of. So I think I don't want to steal your thunder, Jens,
I agree with you.
but that becomes the controlling document for types of units, numbers of units, and things like that is the development agreement.
And the development
Okay.
agreement, it holds people's feet to the fire, but yet it does have flexibility for, whatever makes sense as you go within approval.
So this plan review, I mean, it's already been approved. I kind of agree with everything. I feel like,
It's almost a
I
waste.
guess
of
if you wanted
our-
to just
all
say
of our
that you
time.
accept
Get
it.
it off our agenda.
Yeah.
Wait a minute. I don't. So, have you guys read the development agreement? Because that's what you're giving up.
You don't have control over the
we don't.
development agreement.
That's gonna be between.
That's between the legal team and
Says
Mac
who?
and county.
Says like what language?
That's just all contracts go through the attorney's office, and the development agreement
And we
is
don't
a
sign the
contract.
contracts, the
Does it
commission does.
say
so
anything
that's why.
specific in the planned development
Unit development.
ordinance?
In the new one, it does.
No, in this one, does it?
I mean, I understand what you're saying.
I do too.
I just feel like I'm wasting. Dan's
So I
time.
would like if I were to make a motion, I would
this
say
is-
yes to approve his concept
Right.
plan, but with the expectation that the that the development agreement gets to be seen. We get.
You
know,
don't. You don't though.
But the wording is and or.
Yeah, so section 10, right, isn't it, that talks about.
Yeah, and
So,
or.
Based on the last meeting, I think in part, well, two things. It's not typical in a county or a city to have the planning commission sign a development agreement. That's usually
That's a contract.
that's an administrative thing, so, the mayor or someone from the county commission would sign that normally, or Matt could be delegated to sign that. And so that's what we're doing. I think last time we got so, I don't know what the right word is, over all these things that by stripping it away, this helps you focus on, okay, we're just approving this concept, and then these other things are gonna go forward, and the development agreement will be.
But if you read the development agreement, a lot of different things can happen in it. There's a lot of things that have not been prepared yet that we would be approving without knowing or with
And that's
unseen.
just the nature of the ordinance. I mean, you would rather it be different. I can understand that, but that is the way the ordinance is written.
Well, I think it takes out the public's review when
Well,
it goes to straight to staff.
if I'm understanding your question, you're looking at a pretty specific plan here, right? You've got some density, you've got a layout, you've got all these things. It's not like something totally different than this is what's gonna happen in the end. Is that what you're worried about, or?
Well, if you read the development agreement, I mean, there's language in there that's pretty kind of all-encompassing. The owner is contemplating presenting to the county various land use applications to create the Valley Estates residential community, including necessary land use and subdivision applications. I mean, those are various land use. Various. The word various. Well, what does that mean?
It's going to be a multi-phase development, so as we come in, we'll submit an applications to subdivide each phase. That's essentially what that means.
And it's going to be based on what the market does over time here, because this isn't going to be done tomorrow. And so depending on the market, that's where I'm saying they might go less density with more single-family homes if single-family homes are what are selling.
I'm not worried about the project overall. I'm worried about the process that we're following to make sure that we are not losing as volunteer public or planning commissioners who are the public, that we are not losing our ability to scrutinize projects before they get approved by staff.
So
Is that takes
one
out the
different-
public from this development process, the land use
Because I
decision
think,
making process.
and like that the development agreement is all signed and done by commission. They're the the legal signee, but the development should lay, not the signing, not the even the final approval, but part of the planning process should stay here. That's what you're saying?
Yeah, in this step, this concept, approving this concept plan that is so vague and no
And
nuts
I
and
agree
bolts,
100,000%.
it's not like what we normally do.
But I think because of the language in the Spanish Valley Ordinance, nobody knows what to do. Just like our last meeting.
Well, I'm just saying, you're gonna set a standard now, where you can get cut out of this decision-making process.
With
Land use
TNT, we never seen anybody on step 3.
With who?
TNT, the one right behind Love's that has the little condos, nightly rental. We never seen step 3 on that one. It never came here. We went through step 1, step 2, and we never seen the third one.
Neither did I. I mean, that was pretty much a done deal when I came in.
Yeah. So I mean that's why I'm wondering why it's even here right now. I really am. Because that's how we've done the other one in the past. I mean, we could make
It's
a
just
motion to recommend removing the 2019 ordinance from Spanish Valley to the commissioners. That'd probably be our best bet at this point.
The only thing I can think of on this is that Kristen or Mac's staff, when they go forward, we're basically saying, hey, we approve this, like, go ahead and do your thing.
I mean,
And
you
then
can
they're
see
doing it
where
under
they're
that.
headed with it.
Right.
And we're not going to turn around and turn this into a theme park. You know, this is where they're headed.
But if you did, it
I mean,
would
but
come
that's
back
not
here
the point.
anyway.
I
So
think the point is that
Well, then
this
you're
is a
changing the
public
years.
process.
This is where they're headed, or the sorts, right? It will look something like this when they're done, and that's where we're headed with the development agreement.
Well, I think at some point, I mean, it's private property. It's got to go. At some point, the public gets left out of it. We get left out of it. Like once we say go ahead, we're done. Like it's not our deal. They went through, I assume, a public hearing to get the zone change and the overlay and all that stuff. Like at that point, the public is done with this. Like they had their chance to come in and say their piece. And then we make
But they
a
didn't
decision
have
on
any
this.
information. They don't have any details. They don't know how many hookups there's going to be. They don't know how much water you know.
Well,
There's
they
a lot of
did
unknowns.
because
It was on the
with
original
Sheiks
sheet,
they
but I can't
did.
remember what it was.
But there's but that was on the original plan, right? Which is now a bit more. They're phasing it out, but it's bigger. So this public was scrutinizing it
No,
over what
the
she
land
presented,
has
not-
the land has not changed. It's the same boundary. They're
Yeah,
just showing
I
you
know
what future phases look like.
The land itself got rezoned and applied the overnight accommodations overlay, but we did not see the subdivision, like the plat. Like she had a plat.
Yeah, you saw that.
Gents, I kind of feel that we're in a position that we're not going to vote on this. Do we table it or just
You would
ignore
vote
it?
to leave it to
So,
administrative.
If you go to the commission, you can vote to approve, deny, or I suppose you could even say we feel this is, under the ordinance, it's really the commission's decision, and so.
Or staff? Well, not their decision, but
Just refuse.
I mean,
the
according to
participation
step
in the
3,
process.
Yeah, just say we're leaving this to an administrative process, and when they do get the final development agreement, that will go to county commission.
I think unless there's, this is my opinion, unless you're feeling like you want to deny it, I would say, we feel like this is the responsibility of the commissioners, and we approve it so that you can make that decision. That way we don't have any gray hair of someone saying this was never approved.
So you're talking about county commissioners?
Yes.
Well, my worry there is that they don't know the ordinance as well as this planning body does. So
That's the case with every.
that's why I
Everything's approved.
still feel like yes, let's approve the concept plan, but let's argue that the planning commission should at least have it be an approving body on.
But you just don't have a say in the development agreement at that
That's
point.
fine.
Yeah.
That's fine, but there should be.
So what do
something
you
we
want
could-
to approve?
So it's
Their
like
building
a
permit?
final plat? How about like we used to do? This is like a preliminary, and then there would be a final that we got to look at.
Well, I think the plats come in under the subdivision ordinance, separate
Right.
and apart from chapter 10, right? So whatever the process is under the subdivision
So
ordinance,
they're
we
gonna
follow
be
that
under
for
the
each plat that comes
So
in.
we
December
will see it again.
24.
not as a subdivision.
Yes, well, so phase 1, phase 2, phase 3,
They still
those
have to
will
be
all come
recorded
in.
subdivisions.
We're just
Yeah,
talking
come
about
before
is
you.
the zoning ordinance.
We don't do them.
Whatever
we
you,
don't
if
follow
you've
it.
got a process under the subdivision ordinance for plat review, preliminary plat, and then final plat approval, that doesn't change. None of this changes that.
But then what about the plan unit development that you mentioned? Because if it's over a certain number of units, then it does come
Well,
to.
So
Plan unit
this
development's
is,
chapter 2, and this is chapter 10.
yeah, and this is where we're in a weird Mod Podge area because we have the subdivision chapter that has been updated. Because planned unit development isn't in the 2019 Spanish Valley, remember, because this is subsidizing the 2011, so the only place it is referenced is 2011 for planned unit development. Messy.
I still don't see why we have to do anything.
That's
Yeah,
where I'm at.
Okay.
Like I'm not gonna like
We've
we'll
already
just take the
approved
and
what we
or
have to
out,
approve.
and we'll just say the you just do the or and whatever commission staff wants to do. We don't need to just rubber stamp a pretty picture.
But what are the consequences of? Okay, so you're just, what would your motion be?
To go
Nothing.
home,
Nothing.
nothing,
Just
Okay.
push it.
literally nothing. I mean, I just
We're
feel
not
like
tabling it, but
Sorry,
what does that? How does
we
the
just-
how does that affect the applicant?
Not
Could
at
we
all.
make
He
a
can move.
motion?
He can move
Jens?
forward.
We're in an
Could we
administrative
make a motion,
process.
Jens,
Yeah. It goes to
that
the
we
commission.
ask that they bring the plat, a plat back for us to review?
Sure.
Well, I
But
don't
we
know that
still,
It's
But-
all that is us saying, "Oh, great job, you finished the
Informational.
project," but we wouldn't have any say to
No.
say, "No,
No.
you can't do this."
so is the group opposed to the concept that you're saying?
Not,
No,
So then
opposed to the process.
Somebody make a motion.
Make a motion to approve the concept, and in your motion state that the development agreement is for the county commissioners to approve and sign.
we don't need to make that motion. The ordinance says that.
Well,
So if that's what you're saying, the and or, so
it
just do the or.
Just leaves everything clear.
But I guess what we're contesting is this ordinance doesn't need us. We do 1, 2, and 3. We have no more say. So why are you asking us to
Well,
just
another
stamp
option
a
is to
pretty
say-
picture?
Another option is to say, our role, we've already approved this, everything but the development agreement, so we stand by our prior decision, I guess you could say that.
But then have
in a
to go-
motion or just,
I'd do it in a motion.
okay.
Well, then I'll have to vote no, because the last time I voted no. But I'm okay with the concept.
Yeah, I think it's a great picture. I mean, it's a pretty. I like the different colors. It's nice, you know.
Kristen,
Even
can
like
you
the
roll up
additional
to the recommendation on the approval?
On like the old staff report? Or on our
On the
our
agenda?
current
On the
staff
agenda.
report?
Yeah, what's
The staff report.
what's the suggested approval or denial?
Oh,
Make a motion approving the project plan or make a motion denying the project plan.
And the project plan, AKA the 3 pictures.
Yep.
Those pictures.
I move that we approve the project plan.
I'll second that.
Okay, we've got a motion and a second to approve the project plan.
but we need a change, right? If we're not approving the development agreement, are we okay?
We're
Yeah,
not
just-
developing.
No,
You're
we're
not.
We're not doing it.
That's been
Kristen
omitted
corrected
from
that.
that language.
So with that change.
Okay, all those in favor say aye.
I
Aye. Any opposed?
I think I want to be opposed.
Me too.
2 opposed.
Okay,
I'm-
who's
I'm
the
a
me
no,
too?
3
Nilsson.
opposed.
Oh, but not for the.
It's a
Same
cute picture.
reason.
I just it doesn't matter what we do. So whatever.
Maybe I should say abstain.
No, you
Not
can oppose.
participate
Because
in
you're
the
not
broken-
sure what you want
Not
to
to
vote.
participate in the broken process.
Yeah, it's more of a.
We're
protest
working
vote.
on it.
Jens, what is the consequence of this? Because the next time we get a large development,
I like that idea.
we don't get to see,
Will you put that
We
on the
don't
next agenda?
get to follow the whole process in the approval.
Sure.
I mean, where you would need to stop it is when it comes in for step 1.
Yeah,
You're
for
like,
example,
hey,
so if
we
we
don't
say we're
like
not gonna
this.
approve
Until the
anything,
25 comes
so
in.
until you change the zoning ordinance itself, so if an application comes in before the zoning ordinance is changed for something like this, then you would just say it's not highway commercial.
Explain to your neighbors why a new ordinance is needed.
So the difficulty here is you've got the ordinance the way it is, but also the initial approval nature of that is causing your hesitation.
The initial approval of it being rezoned and applied to, I don't think anybody's really got it.
The plan was approved all back then.
With
That's
a
not-
big gray area.
Yeah, but those lots and the overlay, but then everybody here thought, well, the gray area would come back with something that we would get to approve. Instead, that's not happening. And that's our protest. I'm not
What you have in the gray area is really just an extrapolation of the smaller version. I think when, this is my recollection, when Seek came in, he wasn't saying, I've got this and the rest is going to be, who knows what. It was
Well,
more
I agree with you.
I've never seen Sheik finish a project.
Well, like I say in the beginning, maybe you can approach it a little differently.
I think the protest here is that we got to get rid of this 2019 ordinance.
There you go. Get the new ordinance passed.
I just think we
No.
allowed ourselves to get cut out of the approval process.
Yeah, that too.
Well, it depends on how you want to interpret it. These
What's
days,
that?
people are getting really creative how they want to interpret things. So if automobile service station is up for discussion, then
Did that
so
motion
can
carry?
the approval process, the language, the and. What does and/or really mean?
Hey, and I had my pickup fixed at a Love's station in Cedar City, so
And they did
they
amazing.
did. They got me home.
Okay, building permits. Also, I want to see this 2025 ordinance back in our lap.
Yeah, when are we doing that?
So just a update, I have not been able to touch it since our building inspector left. And so I'm out of bandwidth until we get staff back in my office. At this point in time, if I've asked for a part-time permit tech and a building official, if we can get those in by May, I'm still 2 or 3 months out from drowning before I can look at the ordinance again. So it will not be back on the table for a while.
We need it. And I know where you are, but we need it.
We do need it, absolutely, and so please get your county commissioner. Sorry, I already called out Sylvia. I've put in to be on the agenda for that other job posting, but I will tell you that our administration is fighting that tooth and nail, and they are fussing over minor details instead of just getting jobs posted for me. I'm extremely frustrated that we have been 3 months knowing that we needed a building official and we still do not have one in place. We're going on almost 4 months, almost 5 months by the time they get here. And that's if we get applicants. No one's applying for any of our jobs. It makes me wonder why.
I can tell you.
So-
Would you like me to define that for you?
Anyway,
No,
let's make a motion.
hold on. The direction from the commissioners about that 6 months, it was a no sooner than.
Yeah.
And not a no longer than.
I hope I can get it done by December.
What's the feeling of the commission as far as how much more input is needed from the community?
We already voted to recommend it. I think we'd all vote again to recommend
I think there's a lot of changes, positive, productive changes that could be made to it.
I mean,
So
though,
we've had a number of meetings and a lot of input. I think a lot of changes have been made. I'm just wondering
Well, we haven't had an
So-
opportunity to weigh in, and
what's
have, I feel like we as a planning commission haven't had a time to have a work meeting and discuss some proposals
Or seen the changes.
Right.
so that's something we can do
or
without.
seen.
and I think to fast track it, as soon as I can get back on it, I will summarize all the changes for us and then bring it back. There is definitely a problem where we recommended it and county commission turned it down without discussion. That's a big problem. And so, they just said, well, let's just table it, but they didn't tell us why, going back to the legal side of it. Well,
I think they
why?
wanted more
Wanted more
input.
input.
Needed to be more
Yeah.
But I feel like we've been very amicable to all requests that have been made that are legitimate. I mean, we haven't turned down one. There's one guy in Pat Creek that would like to be recreational
Well, it's
support.
like I tell everybody, though, too. If we make a mistake will come back the next year. I promise. The commissioners, the planning commission will come back and say, hey, this was wrong. The map was wrong, or we didn't recognize this, but because we will make mistakes. But I promise you, a new document that we've worked so hard on is better than
Well,
this document we were
Valley
trying to use
Estates
tonight.
is a good example. We're operating off of a December 2024, a September 2019, and a 2011, and we're jumping between them. And there's going to be conflicts until we get it all in one.
It was November 19th,
You
2019.
were here.
Yes.
It was my
Thanks for your
birth.
hard work.
It was
How
my
you working
birthday, and I
Alright.
sat in here,
I'm sorry.
and it was horrible.
I'm
Motion to
sorry.
adjourn.
Got a motion?
So, but are we
And a
doing
second.
building permits?
We looked at them.
They
What do
look
you want
great.
to do with them?
I don't know.
Kristen, are the
Oh.
building permits just a courtesy for us?
They are.
Yes.
All
Okay.
those in favor say aye.
Aye.
Aye. Any opposed? Ann, are you opposing the adjournment?
I'm gonna abstain.
Goodness, no.
Hey,
Crazy day tomorrow.
That process.
You're